My lord, my lady, you have before you the extracts from Benyon, from Crace, and from Erskine May to validate, I trust, the observations I made to my lady, Lady Hale, at the outset of the proceedings this morning. Can I just explain very briefly where we are now going? I'm going to conclude my submissions on compensatory damages, deal in one case in relation to vindication, the case of Ashley that was referred to, make very brief submissions on the law relating to exemplary damages, because, as Mr. Westgate said, there appears to be little, if anything, between the parties. I shall then, as it were, give headlines as to how that applies to our particular case. Then we have sought to emulate or to mimic Mr. Hussain and his team in providing written submissions on the Hardiel Singh issues in the WL case, and I will introduce you to that document, but not waste unnecessary time in reading it through one or two, as it were, emphases and footnotes. And I shall then, if I may, hand over to Mr. Tam, who will deal with the factual matters relating to the alleged non-disclosure, both in the policy and in terms of the duty of candour, to whether it's deliberate or fell short of that in some other way. So where I was to deal very briefly with the Kuwait Airways case, which you will remember was relied upon by my learned friend Mr. Westgate for this proposition, that in a case where the Iraqi Air Force had captured and converted in legal parlance the aircraft of Kuwait Airways, whether or not they were able to argue in a tort of strict liability, which we accept has affinities in legal terms with the tort of false imprisonment, whether they were able to argue that the damages should be reduced on the basis that the government of Iraq or some other Iraqi entity would in any event have converted those aircraft. And the decision of the House was that that was not open to them. But in our respectful submission, the passages that were read from the leading speech of Lord Nichols and in Lord Hoffman, they were at 1094 and 1106 of the report, which just for the note is in volume 20 at page 122, can be entirely explained on the basis that what was being juxtaposed was an unlawful conversion by A. Would that, in fact, give rise to no damages if there was to be anticipated an unlawful conversion by person B? And we say that is distinct from the present case in two salient ways. First of all, we're not dealing with a hypothetical third-party imprisonment, and secondly, we're not dealing with a hypothetical alternative unlawful imprisonment. We are saying we were in the position where, albeit flawed in public law terms, we could have taken exactly the same decision at exactly the same time, pursuant to the lawful policy that was actually concurrent and indeed in the public arena. So that's what we wish to say by way of response to that. The then issue that was raised was the question of whether more than nominal damages would be available for vindication of the rights of WL and KM, the appellants, merely by reason of the fact that they had been, on this hypothesis, unlawfully detained, the victims of a tort of false imprisonment. And in our respectful submission, the Ashley case, which was referred to by Mr. Westgate, does not sustain the proposition that that is an inevitable consequence of the finding of the tort. One may remind oneself that Sir Harvey McGregor, in his book on damages, well-known and established book on damages, which was referred to in the judgment of the Court of Appeal at paragraph 91 at the Weekly Law Report, where there is no loss or damage, such judgment would be for nominal damages only. That was under the rubric of the tort of false imprisonment, describing it, of course, as a tort actionable per se. And we say there was nothing in the speeches in the Ashley case that actually sought to undermine that proposition. Can I just then ask you to look very briefly at Ashley, and again, very conscious of the time, just certain of the key passages in the key speeches in that case. As you will remember, it was an unusual case because the issue simply was, should the claimant be entitled to proceed, where it was the family of the person who was killed by a police officer acting as has been held on the basis of self-defense, was the family able to pursue the matter on the basis of battery, tort of strict liability, and that there would be some useful purpose, in effect, to be served by allowing them to proceed. And
that was because, in particular, it was agreed that they wouldn't get anything more for as damages for battery than they would get under the other head. That was a critical point.
That's so, my lord. I accept that. But can I just look though just at certain of the dicta there? Now this is in 174 at 18. And again, I'm very conscious of what my Lady Hale said, I think extra purely about the danger of cherry-picking and the dislike of counsel cherry-picking favourable passages.
Which they like,
needs must, my lady, in this particular case. And I hope that...
I know why you have to do it, Mr. Camargo. Doesn't mean to say I have to like it.
Yeah, that I entirely accept. But I hope that here I'm not ignoring, as it were, rotten fruit and everything I'm going to pluck is edible. Just the speech of Lord Scott at the outset, one does notice, and I don't think my learned friend sufficiently emphasised this, that at the conclusion of the passage, he deals at 22 with why, in this particular case, he's saying in general terms, compensatory damages can, of course, themselves serve a vindicatory purpose, but it's not going to be available in this particular case because of the unfortunate circumstances of the fact. But then he went on to say, nonetheless, it should continue for various reasons. And then at the foot of 23, paragraph 23 at page 977, he says, the Chief Constable declines, as he was entitled to do, to admit liability on the assault and battery claim. That being said, I can see no ground upon which it can be said it be inappropriate for the claim to proceed for vindicatory purposes. Whether if liability is established, the vindication should be marked by an award of vindicatory damage or simply a declaration of liability is, in my opinion, unimportant. Now, what we say follows from that is that Lord Scott clearly didn't consider that it was necessary in every case to have a vindicatory function by an award of damages, that a declaration of liability would or could suffice. My Lord Roger, if I can go again to paragraph 60 and his speech in that case. This is at page 985. And really what my Lord said is epitomised in the first two sentences. A claimant has no cause of action negligence unless he has suffered injury or damage. By contrast, battery or trespass person is actionable without proof the victim has suffered anything other than the infringement of his right to bodily integrity. The law vindicates that right by awarding nominal damages. And then my Lord goes on to consider whether compensatory damages could also serve or fulfill the same purpose. But in our respectful submission, that points away rather than in favour of the proposition that one simply is entitled to damages of a substantial kind for infringement of the right to bodily integrity per se.
Is there any authority which actually does discuss the circumstances in which vindicatory damages should be awarded?
If there is, it's not in the many volumes, I think, before your court. Other, of course, than the Mosley case, which, again, it was a discussion in the context of libel. And there, with great respect, I mean, one could quite clearly see this wasn't a case in which Max Mosley's dignity was bound to have been offended in some other way. I mean, having decided his right to privacy and the privacy of his sexual preferences was being invaded, in those circumstances, one can understand why vindication, you have to establish some, but beyond that, and that was shown to my lords, and we just simply say it's a different circumstance. And then Lord Carswell and Lord Newburgh, in fact, dissented on the fact of the whether or not it should go further. But I just, again, I think that it's not inconsistent with the propositions that I've advanced when they came to consider the damages issue. 80, para 80 at 991. Just below B, I'm unable to agree with Lord Scott's view of a suitable case of what he terms vindicatory damages. In my opinion, the only function of damages of this kind, where there's no other remedy, will meet the case, there being perhaps no provable loss, and you've heard my submissions on that, except a nominal award of damages to establish formally the validity of the claim. It is a time-honoured way of establishing a point of principle or vindicating wounded feelings or character. So again, he cites Salmond and Houston in support, so that's consistent with McGregor as well. And then Lord Newburgh took an entirely a different approach, but what he said in effect, and I'm not going to trouble you with reading the entirety of it, what he effectively said is, it's really at 116, he said, obviously, there he says, the activities of the executive are legitimate, indeed, compulsory source of inquiry by the judiciary. But what he went on to say was that actually the way in which one identifies or reacts to unlawful action of that kind is by way of declaratory relief. And nothing he said, as it were, supports the proposition that merely for the purpose of vindication, one should have some substantial award. So that being the high watermark of the authorities relied upon by Mr. Westgate, that's our respectful response. Finally, under this heading, and I hope I can deal with this again with reasonable celerity, the exemplary damages we deal with exhaustively at section 11 of our printed case, starting at page 70. And Mr. Westgate, I remind you, has concentrated his file not on the analysis of legal principles, but on their application to the facts, and Mr. Tam will address you on those.
Could I just ask you on the facts? I mean, it strikes me as a slightly unusual situation where we're presented with a lot of paper and we're asked to draw inferences, make assumptions from the paper without a trial ever having taken place. And I wonder whether there's any precedent for the award of that kind of, those kind of damages without parties actually being put to the test of evidence.
I'm not going to, as it were, preempt Mr. Tam. I can show from my knowledge that that is a point he is going to make. It is wholly unfair, we will be submitting, to make a finding of bad faith against a group of persons who have not been given the opportunity to defend themselves, have not been subject to cross-examination. These matters were explored to an extent below, as will be explained, and in our respectful submission, there is no precedent for making a finding of that kind simply on the paper, unless, I suppose, unusually there were an agreement that that was a function that we would, that one would permit the court.
Yes, well, agreed facts. That's
our stance.
Yeah. Right,
I'm glad to see that Mr. Tam agrees that that will be our stance, but that is so. So can I just say this, just by reference to our printed case? None of this, I suspect, is disputable except in one possible instance. We say, really, 5 propositions. Firstly, the only category that, of course, is relied upon here is the first of Lord Devlin's famous trilogy, oppressive, arbitrary, or unconstitutional action by servants of the government. And we say with respect that that is a necessary, but it is not a sufficient basis for an award of exemplary damages. See what we say and set out by authority in paragraphs 11.8 and 11.9 of our printed case. It is indeed a remedy of last resort. So the second proposition is, as it were, truly outrageous behaviour is required. See the same paragraphs. Third proposition, ordinarily, bad faith at least must be established. See paragraph 11.10 at page 73. That the cases relied upon by the appellants do not, in our respectful submission, undermine that. They refer to a statement in the speech of Lord Nichols in Kudus, but what they fail to acknowledge is that the context of that statement was the previous paragraph in his speech, which we set out at 11.8, paragraph 63. And again, your lords and my lady can just cast your eyes down and see the kind of epithets and description that Lord Nichols gave of the sort of behaviour that was required before the remedy of exemplary damages was awarded. And we say in relation to the Bottrill case, it's fairly acknowledged to be a New Zealand case where statute makes a different basis for the award of exemplary damages, but nonetheless, Lord Nichols, again, against the background expounding the general common law, again says effectively what was said in Kudus. And again, if my lords and my lady are interested in exploring further or reminding themselves of that speech, I would ask you not just to look at paragraph 24, but to look from paragraphs 20 to 26 of Lord Nichols' speech in Bottrill, which is in our authorities bundle, whether in the place in which we've located it or not. Mr. Tam will tell me in a moment. And then finally, while he's conducting that research, bearing in mind, of course, that the function of exemplary damages unusually is to punish, there are various factors that may be taken into account as factors contradicting the need for award of exemplary damages. The first is that there are other methods of expressing disapproval of outrageous behaviour by public authorities. And Lord Scott, again, we cite page 74, 11.16, in ways peculiarly pertinent to the present case, even if, which we dispute, Mr. Westgate's analysis has any force. In a case where the defendant is not the wrongdoer and damage are in any event going to be net out of public funds, how can it be supposed that the award of exemplary damages adds anything at all to the deterrent effect of the trial judge's findings of fact in favour of the injured person's condemnation of conduct in question? Well, here the first part may not be germane, but the second is certainly going to be germane, and we ask ourselves, on the assumption that the Supreme Court were to go further than the Court of Appeal and below, one would ask oneself again whether that would not, in accordance with Lord Scott's philosophy, be sufficient. Another factor is whether or not there is some sense in which the claimants themselves have contributed to the situation in which they find themselves, and that again, with respect, is German, that's 11.19 at page 158. And the other matter, which is of some interest, again, is the procedural matter, which was examined in a Court of Appeal case called Riches, which we refer to at 11.17. And what effectively is there said is, if you're going to award exemplary damages, which are not to compensate but to punish, you need at any rate to be able to distribute them fairly among the victims of the outrageous behaviour. And in circumstances, as the Court of Appeal noted, where one simply here has two lead cases, we ask ourselves, how can that be satisfied? Why should these two particular appellants receive a windfall in such circumstances? So what we say then, before I going to WL and then leaving the floor to Mr. Tam, we deal with the application of those principles to the present case between 1120 and 1126, pages 75 to 7. And what we say, in short, is 1, the conduct, insofar as it merits disapproval, and we certainly accept that it does, it's already been marked in stringent terms, and if any deterrence were needed, it's already been provided for. Secondly, we do note the fact that there are huge financial consequences potential in this litigation, not only, of course, as to the costs that have been incurred to date, see 11.23 at page 76, but as your lordship and my lady will appreciate, standing behind these two lead cases are persons, as it were, in 4 figures of persons who are arguably subject, of course, to them being able to establish the application of unlawful policy to them, if Mr. Hussein's argument is right, all entitled to some form of compensatory damages, and that's another factor to be taken into account. If that were to see, does one really need more by way of exemplary damages? The author's own misfortune point, I needn't labour, you have my submissions on that by their misdeeds they were inevitably to be detained. We deal with that at 1120 at page 75, and we deal with the technical aspect of the fact that these particular defendants would receive a windfall, and it would not be able to be, as it were, shared in the court's judgment against between all the possible persons who would be entitled to that collateral benefit. We deal with that at 11.24. So that's all that I wished to say then, apart from one matter, which perhaps is of some concern. We say that the appellant's case is founded on a platform with 2 pillars. The first is the outrageous behaviour, as they would characterise it, in having a secret policy, undifferentiated, etc. That's one pillar. And the other pillar is the conduct of these particular proceedings in the lack of full candour, again, which will be dealt with, as a matter of fact, by Mr. Tam. Our submission is that these are not matters that can sound in exemplary damages at all. We submit that exemplary damages are designed to support a tort. It may be one could envisage a breach of contract too, falling within the categories identified by Lord Devlin, and with the additional elements that would be required. What we say in relation to a breach of any duty of candour, if such were found, is that the way in which the courts respond to that would be by an award, let us say, of indemnity costs. One cannot simply, as it were, transfer that alleged misbehaviour into, as it were, to inflate what one would otherwise get from the tort. I just say this by way of postscript. Of course, we could envisage a situation in which the fact that we had made insufficient disclosure, with the consequence that adverse inferences of fact would be made against us, might then lead a court, hypothetically, to decide that the tort was of such an outrageous nature as to generate the right to exemplary damages. But that, again, merely reinforces the fundamental point that it would be an adjunct to the tort. It wouldn't be an independent remedy for a failure to discharge one's duty of candour owed to the court. So may I then pass to the last head of submission that I'm vested with responsibility for advancing, which is the question, the WL question, as we've called it, the particular matter as distinct from the generic matters. And we've, as I say, sought to emulate as best we can the way in which this has been advanced by Mr. Hussein by preparing a written outline submission that I hope can now be distributed. Thank you. And can I just explain how it was contrived in order to make it as user-friendly as such document ever can be? What we have done, and this owes very much to the industry, in particular of Mr. Johnson and my juniors, what we have done is to set out to identify where our submissions in our printed case are to be found, to identify where Mr. Justice Davis and the Court of Appeal determination on this issue is to be found, and then under each of the headings which are the subject of debate, or in one instance perhaps the subject of concession, factors to be taken into account in the context of the Hardy-L-Singh principles and the approach of the Convention courts, abscond risk, risk of offending, voluntary repatriation, non-cooperation, exercise of appeal rights, and finally and separately the returns directive, which is also Mr. Tam's special subject, which he can address you when he rises to his feet. What we've sought to do is to set out, first of all, what we say are the policy considerations for saying that each of these factors should be taken into account, and we've then referred to authority in other cases, again giving them the appropriate bundle references which support our propositions, and so that you therefore, of course, as the Supreme Court, you are free to take your own view about any of these matters, but the way in which it's been expressed in the appellate courts to date is in our respectful submission, of some particular assistance. Can I just then deal with, without, as I'm aware, reading this, just deal with 2 or 3 matters that have come up in the course of argument? First of all, Mr. Hussain waxed eloquent against what he said was the anathema to the common law of preventive detention. In our respectful submission, that simply does not recognise the discrete category into which these particular claimants or appellants fall. The fact of the matter is that they are being detained not for the purpose of preventing them from offending. They are being detained legitimately on this hypothesis in order to facilitate their removal. And what we say is, in that context, there is no, as it were, preventive detention at all involved. The detention is validated by the fact that they are to be deported. The other factor, this one in particular taken into account, is obviously a factor that it's appropriate to take into account. It would be extraordinary in our submission if you are faced with persons who face deportation only for the reason that their presence is thought to be not conducive to the public good, and the rationale for that conclusion is that they have committed serious criminal offences, that one should not be entitled as a Secretary of State to take that into account as a fact, if I may put it this way, against release, because that's in a sense what the argument then all becomes about. It would be just inconsistent with the whole way in which their case had been properly treated. The other matter, and this is I'm responding to a particular point made by Mr. Fordham, is, as he said with his usual formidable skill, that if you look at Chahal, Chahal restricts narrowly the circumstances in which one can detain uniquely for the purpose of facilitating removal. But if one looks, and it's most convenient to look at this through the citation in the Court of Appeal's judgment below, my lords and my lady would go to page 2195, and the paragraph that is there cited. This is where the Court of Human Rights, and it's quoted at paragraph 61, said at paragraph 112 of their judgment Article 51F does not demand the detention of a person against whom action is being taken with a view to deportation be reasonably considered necessary, for example, to prevent his committing an offence or from fleeing, and in this respect is Article 51F provides a different level of protection from Article 51C. Indeed, all that is required under this provision is that action is being taken with a view to deportation, etc. So what they are there saying is, you don't actually need to go so far as to say, we're going to detain you because we're concerned either about absconding or committing an offence, which they agree as being on the same platform. But clearly, they're saying it's not necessary for you to have that in mind. They're clearly envisaging the possibility that it's entirely proper. It is entirely proper to have it in mind. So that's my response to the way in which Mr. Fordham puts it. I just want to deal a little bit, not out of just personal affection for the case of Tan T. Lam, on the issue of voluntary repatriation, because in our submission it can be misunderstood as being a judgment which has been confined in the context of voluntary repatriation simply to the discrete Hong Kong legislation. So if my lord and my lady be good enough to look at that in Tan T. Lam.
It's volume 9.
It's volume 9, tab 92. Thank you. This was what was colloquially known, of course, as the Vietnamese boat people. And the issue of a voluntary repatriation was dealt with by the Privy Council through the opinion delivered by Lord Brown Wilkinson. It is right to start, before I go to 114, to 111, where the Hardiel Singh principles are set out in the context of a power to detain a Vietnamese migrant pending his removal from Hong Kong, and given that vocabulary, unsurprisingly, they adopted a Hardiel Singh approach. And then they went on to deal with the fact that there had been, in deciding what was a reasonable period of detention, another aspect of Hardiel Singh, they referred at letter G to particular Hong Kong legislation, which provides expressly that in deciding whether or not the period is reasonable, regard shall be had to all the circumstances. And incidentally, it may be worth recollecting at this juncture that Mr. Justice Wolfe, as he then was, did make clear that the Hardiel Singh principles would always be, as it were, fact-specific. One would need to look at the particular circumstance of the fact to determine whether or not they'd been violated. The Hong Kong legislation said, it provided that regard shall be had to all the circumstances, including in the case of a person detained pending his removal from Hong Kong, the extent to which it is possible to make arrangements to effect his removal. Well, that, of course, is actually intrinsic to the Hong Kong, as the Hardiel Singh principles. If one can't any longer remove, the legitimacy of the detention lapses, and whether the person has declined arrangements made or proposed for his removal. Therefore, the subsection expressly based on the requirement that detention must be reasonable in all the circumstances. The Hardiel Singh principles, but imposes specific requirements that in judging such reasonableness, those two facts should be taken into account. Now, what I submit there is the Privy Council didn't say, but in requiring these two facts be taken into account, it seems to us that that's inconsistent with what one would ordinarily interpret to be reasonable. And one notes over the page that the reason that Hong Kong legislature, LegCo, decided to introduce this particular provision was that there had been earlier decisions, which they referred to between A and B, in which the Hong Kong courts had decided that those matters were not, in fact, relevant. So what one had in Hong Kong was something that fortified Hardiel Singh or explained Hardiel Singh and directed attention to the fact that within the general rubric of reasonableness, two particular factors, including the possibility of voluntary repatriation, ought to be taken into account. And that's the context in which, at the foot of page 114, between letter H and 115A, having said that, between G and H, the Vietnamese migrant is only detained because of his own refusal to leave Hong Kong voluntarily, such refusal being based on a desire to obtain entry to Hong Kong, to which he has no right. In assessing the reasonableness of the continuing detention of such migrants, Section 13D1AB2 requires the court to have regard to whether or not the persons declined arrangements made or proposed for his removal. In their lordship's view, the fact that the detention is self-induced by reason of the failure to apply for voluntary repatriation is a factor of fundamental importance in considering whether in all the circumstances the detention is reasonable. And our submission is that that is not just simply an exposition or reliance upon the statutory language. The statute simply makes certain factors which would ordinarily be taken into account, mandatorily be taken into account, and the Privy Council, constituted as it was, as my lords, my lady can see, thought that it was a factor of fundamental importance. So we ask you to bear that in mind and the high authority which it contains. Finally, exercise of appeal rights. We, of course, recognise what Mr. Fordham said about, to an extent, that confronts a person with a choice. If an unsuccessful appeal and the time spent in pursuing it is not to be taken into account in assessing the overall reasonableness of the period of detention, the persons in the appellant's position do have a choice. But it is odd, in a sense, submission to say that because they've been given the right of appeal, therefore they're not, as it were, to be in any way given a choice, as it were, to be given, as it were, free run, to use the vernacular, in exercising that particular right. It is, and of course the question of self-induced was the words used in Tanti Lam, equally here. It is their own choice. If they have a good case, it's nothing to do, as Mr. Hussain said, with an assumption of executive infallibility. If the executive have got it wrong, the application or appeal will succeed. If, on the other hand, the executive have it right, then in those circumstances, the appeal will fail. And Mr. Hussain moderated his submission by saying, well, if it's clearly a colourable appeal, vexatious, limited chances of success, then in those circumstances I accept this can be taken into account. But once again, the moment he opens the door at all, one asks, well, at what stage does, as it were, the door close again? We say, and this perhaps is the explanation of what otherwise might be a somewhat taut sentence in the middle of paragraph 12, this is assuming Mr. Hussain is right, but what the court would have to do in determining whether or not a exercise of appellate rights was vexatious or frivolous or doomed to failure. At the time when a Hardiel Singh challenge is made, i.e., the High Court is being asked to determine whether a reasonable period has expired, the High Court would then be compelled into the position on Mr. Singh's analysis of determining how strong the case was. And yet that would be to usurp the authority of the Immigration Appeal Tribunal, the AIT now, the Asylum Immigration Tribunal, who are vested with the power to assess the merits of the underlying challenge to deportation. We say that's not how the system ought to operate, and we do deal with the question of uncertainty and arbitrariness as well. At 13, we deal with the particular facts of the case as to how an appellant is able to postpone the moment of his removal. Just I remind you that my Lord Simon Brown, Lord Brown, in the I case, did say, of course, if at the time you make these applications or appeals, the government is unable to remove you anyhow because pro tem, for example, the Congo won't receive you, then of course that time doesn't matter because you've not been responsible for elongating the time. That's the point that you've made on the basis of Chahar. But we say, of course, if on the other hand you are doing it in circumstances where you could otherwise be removed, then the time ought to be deducted. Prospect of removal, I don't know what the issue between us is. Obviously, we don't say a mere hope. There has to be a prospect, and it's got to be, as it were, a real prospect, but one can't set the hurdle there too high. Returns directive, as I say, is my learned friend Mr. Tan's special subject, and we end by respectfully submitting that in relation to the invitation to the court to re-evaluate at this stage of this long hearing the new primary facts, whether or not it's jurisdictionally available, which no doubt it is, it certainly isn't the function of a Supreme Appellate Court. If the principles that Mr. Hussain advances are accepted, then no doubt Mr. Lumba, the WL, will be depending in a position to make a swift first instance claim to seek his release before a forum, in a forum vested with the power properly to investigate all the facts as they then are. My lord, my lady, unless I can in any way assist you further, I would yield the floor to Mr. Tan, who will deal with two matters. One, no doubt, very briefly, the returns directive point. Do you wish to do it? Yes. If necessary. Yes.
Well, just one question. I mean, do the bail judges have regard to the Hardiel-Singh principles, or don't they?
No, I mean, it is independent of the... I mean, the legality of the detention is one matter. It's assumed, if you're applying for bail, that you are legally detained. And therefore, as I say, as you'll see from Mr. Justice Blake's speech, there isn't
Thank you.
any... Those are my...
No, thank you, Mr. Beloff.
Yes. Okay, I'm sharp.
May it please the Court. In relation to the returns directive, can I just say this, as we've dealt with the issue quite fully in our printed case, and also you now have the summary in the note on WL, unless there are any specific matters on which I can assist the Court, I propose to let that speak for itself, save only to make one factual observation, which is that if your Lordship's Ladyship look at the facts of WL's case, there are times to which we've adverted in the printed case at which WL has counted as an asylum seeker for the purposes of the European directives, and that follows from the recent decision of this court in Zedo, Somalia, that if you're a failed asylum seeker and then you make a further claim or you make further submission saying I'm still at risk and I'd still asked to stay in the UK on that basis, you once more become an asylum seeker for the purpose of all the European directives. So a person in WL's position would, and having said what he has said, will arguably swap between, from time to time, between being a person whose removal is being proposed. So if the return directive applied to him, he would fall under that. And then from time to time, he would swap into the category of asylum seeker, where the 18-month time limit in the return directive is not applying. And the relevant dates are as follows, that when WL was first served with a notice of intention to deport in May 2006, he appealed against that. He says on asylum grounds that the AIT later found that his appeal did not include any claim for asylum. That decision was made on the 15th of December 2006, so there's an arguable problem there about whether he was actually an asylum seeker during that period, but he might have been. Following the dismissal of that appeal, he made further submissions on the 15th of August 2007. Those were unequivocally asserting that he was at risk on return. So following ZO Somalia, on that date, he once more became an asylum seeker. So if the return directive applied to him, and if the UK had made the appropriate arrangements in its detention arrangements, he would once more have become detained as an asylum seeker rather than as a person subject to return. And so the 18-month time limit would have stopped running because of the decision Kadzoev, which we've explained in our printed case.
And this was because he was regarded as having a fresh claim, was it?
Well, because for the purposes of the European directives, he's regarded as an asylum seeker. And the decision in Kadzoev, for the reasons we've set out, says that if you are detained as an asylum seeker, the 18-month time limit in the return directive is no longer running. The challenge that the Secretary of State rejected his submissions, and the challenge that WL brought to that wasn't determined until the 10th of February 2009, because it was stayed behind a lead case which reached the Court of Appeal. On the following day, the 11th of February 2009, he made fresh submissions, again including Refugee Convention and Article 3 grounds, i.e. asylum grounds. So he once more became an asylum seeker at that point. At some stage, he appears to have dropped the asylum aspects of his claim, but there will have been a further period when he will have counted as an asylum seeker for the purposes of the return directive. And so when learned friend Mr. Hussain says that we accept that if the return directive applied to him, he would by now have released, actually that's not right, because it would depend on exactly which periods of time have counted and which would not have counted. And that is a matter which we have not been able and would not be able rapidly to determine. So unless there's any other aspect of the return directive on which I can assist, I propose to move on to the factual matters in this case. Sorry, sotto voce, learned friend Mr. Hussain says we have accepted what we say at 1512 is that we don't draw attention to the detail of the swapping backwards and forwards between being an asylum seeker and not being an asylum seeker in an attempt to argue that he would not yet be regarded as having been detained for 18 months. That is not with respect and acceptance that he would be regarded as having been detained for 18 months for the purpose of the return directive, because the question of whether under the return directive he has been detained for longer than the limit depends on, amongst other things, on whether he was to be counted as detained as an asylum seeker for the periods that I've just drawn attention to. Those matters are uncertain. But the point is that in WL's case, there are periods where he would have swapped between the categories had the return directive been applicable to him. Yes. Yes. Well, and I'm reminded, of course, that this is a matter of detail. The main point is that the directive is not directly effective. Yes. We've opted out of it, and there is no route by which it can be held to inform either Article 5 or the common law. And we've set all that out. I don't want to go back over that. In relation to the facts of the case, my learned friend Mr. Westgate spent some time, I think on Tuesday, painting a picture which some people might think was rather an unattractive one. It's not part of our submission to try to excuse the inexcusable or to pretend that things in the Home Office were perfect. And learned friend Mr. Beloff set that out really at the outset of his submissions. It is clear from the documents that there were things done which should not have been done, and there were things which should have been done that were not done. But the point for present purposes is this. Learned friend Mr. Westgate was able to paint that picture because we gave him the paint and the brushes with which to do it. And not only that, but both before Mr. Justice Davis and before the Court of Appeal, those courts were able to look at that, at what had been painted, and to take their own view of what the documents and the facts showed. The point really is this, that all of the substance of these matters have been looked at by the courts below. Findings of fact have been made by them. They've been made in circumstances in which the evidence has been able to be looked at in more detail and with more time than is available here. And in a forum where such evidential examination and factual findings are natural. We respectfully say that it is not open to the appellants simply to ask this court to revisit those factual findings and to ask this court to make an intensive review of the very detailed background evidence that there is in all of the appendices and to make fresh factual findings on the basis of such limited examination and limited argument. The reality is that practically all of the material was disclosed before the Court of Appeal, and the appellants made detailed submissions to that court on the same lines.
You only gave them the paint, or some of the paint, in time to enable them to have an impressionistic painting rather than a pointilliste.
Well, with respect, before Mr. Justice Davis, all of the key documents were already available. We did give more before the Court of Appeal. There's a timing problem there which we accept and for which we've apologised. I'll come back to that if I may. But the appellants were able to make detailed submissions in respect of the new documents. I know a lot of work was put in over the weekend and in the evenings during that week, and we have apologised for that, and we apologise again for that. If they had needed more time to collect their thoughts and make further submissions, we could not possibly have opposed that. But we did spend time before the Court of Appeal looking at those documents, looking at all the evidence, and having argument about what they mean and what could be shown. And the Court of Appeal made their findings of fact, and indeed went further than Mr. Justice Davis had done in some respects in their conclusions on that. But to demonstrate that the argument that learned friends seek to make now is in substance no different from what both Mr. Justice Davis and the Court of Appeal looked at, can I invite the Court, please, to go to Appendix 1A, it's in Core Volume 2 if that's the most convenient place, and go to page 402. You see that these are the supplementary written submissions on the unpublished policy and recent disclosure. On the right-hand side, page 403, there is the complaint about the further disclosure that was given on the Friday before the hearing started. At 404, paragraph 7, you see the assertion that the late disclosure gives rise to the following very serious issues of fact. Whether the unpublished policy or practice was one of presumptive detention or one of blanket detention of all FNPs, whether respondents' officials knew or were reckless as to whether they were acting unlawfully, preferring to leave it to the courts to remedy the illegality for public relations reasons in those cases that were challenged, whether the respondent actively discouraged disclosure of his true policy or practice, whether caseworkers, including those who authorised detention in these cases, genuinely considered release in individual cases or had been instructed to give an appearance of such consideration while in truth applying the unpublished policy or practice, whether the courts were intentionally or recklessly misled by the respondent's officials, and in particular Hanny Hunneman within the Judicial Review Unit, who submitted sworn statements, technically I don't think they were sworn, they were witness statements, in WL and her superiors. And then if you then go on to page 406, you see the submissions developed, just referring to the headings, top of 406, respondent operated policy or practice of blanket detention. There's a summary there. On the right-hand page at 407, history of the respondent's stated policy on immigration detention. and then 408, history of the unpublished policy. And you see that there are detailed citations of the individual pieces of documentary evidence. On the right-hand side at 409, you'll see paragraph 16 is in bold. The bolded paragraphs are references to the late disclosure that was given by us just before the hearing. The value of that is you can see how it fits into the picture that had already been painted before Mr. Justice Davis and with other evidence that was already available. If you go on through 410 and 411, there's nothing bold there until the bottom of page 411. And in fact, I'm not sure that was intended to be bold because it's only half in bold. And so on. And you go through it. Every so often there's a bold paragraph in amongst a lot of paragraphs in normal type. And all of this was before the Court of Appeal, and it's the basis on which they looked at the all of the evidence. If you go on to page 428, so after setting out all of the all of that documentary evidence, there's a section of the conclusion of those submissions going on to page 432. At page 433, the next topic is addressed. Respondent knew or was reckless as to the fact that his policy or practice of blanket detention was unlawful, but preferred to abdicate the task of release to the courts. And again, following a similar pattern, you see a number of paragraphs in normal type, and then at 113, a bold paragraph there. Heading on the right-hand page, 435, respondent actively discouraged disclosure. And 436, there are subheadings referring to disclosure of the February 2007 process communication actively discouraged. And then on at least one occasion, the caseworker advised to manufacture reasons for detention. That's one of the few topics on which the majority of the evidence is in bold, but it's quite clear that the appellants have dealt with it, and the Court of Appeal did have all of this before them. Going on to 438, disclosure of the Cullen criteria in reasons for detention was likewise discouraged. That's just above paragraph 128. At 439, the respondent decided not to publish the Cullen criteria. 440, respondent published misleading documents during this period. 441, disclosure was ultimately forced on the respondent. And then over the page at 442, going on to the next topic, respondent knowingly or recklessly misled the AIT and the courts. 444, respondent knowingly or recklessly misled the court in WL's case. And then finally at 448, there's a topic of the defendant's continued failure to comply with his duty of candour to this court, that's the Court of Appeal. So having had a canter through that and having seen the volume of material which was referred to and the detail of the submissions that was made, can I invite the court please to take the 48-page document that's been produced this morning, which is the update to Annex B of the appellant's case.
Is this the chronology document?
It's not the chronology itself. There's a 48-page update that's entitled Submissions on behalf of the Appellants, the Unpublished Policy and Lack of Candour. At page 3 of that, again, I'm just going to draw attention to the headings. There's headings dealing with the published policy, and then going on to page 5, the unpublished policy or practice. Submission 1, respondent operated hidden blanket policy or practice which was not subject to Hardy or Singh principles. And perhaps while I'm going through this, can I draw attention to the fact that occasionally you'll see documents which are in Appendix 5. So, for example, on page 6, at paragraph 14, there's an email which is in Appendix 5. And at 15, there's a draft of guidance which is in Appendix 5. The significance of that is that is the new disclosure before this court. And similarly, if you go through the document, you will see that the Appendix 5 documents are pretty limited in comparison to the documents which have been disclosed now, years ago, and which the appellants have had. There's nothing substantially new in what has recently been disclosed. The next heading on page 9 is about the Secretary of State's blanket practice or policy. At 10, the application of the published policy was actively discouraged. 12, proposal drafted for a policy containing a presumption in favour of detention. The proposal never advanced the Home Secretary, still less adopted. 14, a heading about the Cullen criteria. And at 16, submission 2, Secretary of State and her officers knew or were reckless as to the illegality of their actions, referring to leave it to the courts to remedy the illegality. 22, submission 3, respondent actively discouraged disclosure of her true detention policy or practice. At 24, submission 4, there was a deliberate decision not to publish the hidden policy. At 28, subheading, Secretary of State was forced to reveal the existence of the hidden policy. And then over the page at 29, the courts were intentionally or recklessly misled by the respondent's officials, referring again to the witness statements. And so on. So, in relation to the substance of what is before the court in this document, you can see that it is really the same submissions that were advanced to the Court of Appeal, advanced in some detail and in a form which the Court of Appeal was able to consider, and, as I say, on the basis of which they made their findings.
So you're really inviting us to compare this with the spreadsheet, which had the headings in it and the side notes as to the inferences that the Court of Appeal were invited to draw. Are you?
Indeed, the spreadsheet again is a useful document for doing that, because you can see the complaints that were very specifically being made about the new disclosure that had been given after Mr. Justice Davis' judgment and before the Court of Appeal's hearing. It included the allegations, for example, in the first column of the first page, the allegations that David Wood's statements omitted reference to directly relevant events and documents and failed to discharge the duty of candour, the allegation that his evidence was intentionally misleading. On the second page, in the first column again, respondent actively discouraged disclosure, and David Wood's evidence on this point was intentionally misleading. So these are all the allegations that were being made by the appellants, and the Court of Appeal had all of this, and they made findings on those allegations. We respectfully say that both Mr. Justice Davis and the Court of Appeal, having made findings of fact, there is a real risk if this court were to depart from the usual practice and embark on the exercise which learned friends are asking for. That there's a risk in particular of findings of fact being made in a process of litigation by soundbite, because this court is rightly going to focus on the important issues of law that have been raised and argued extensively. Whereas certainly Mr. Justice Davis and then the Court of Appeal, because of the circumstances in which they were being asked to look at it, had spent rather more time and were able to devote more attention to the detailed evidence and the facts of this case. I should make it clear that we don't accept all of the criticisms and all of the allegations that are being made by the appellants. that we can see that the arguments that they put forward, but there is perhaps just one example of a matter on which they place great reliance, but in context, one can see that there are other interpretations, and that is the email referring to the Magna Carta rubbish, which my friend Mr. Beloff referred to. On its own, it's a great soundbite to give to a court and say, look how terribly the Home Office officials are treating the rule of law. But in fact, as my friend Mr. Beloff said, if you look at it in context, it's in the discussion of whether the presumption or presumption of liberty is a legal presumption or a policy presumption and what the law ought to be. And that particular sentence, the whole sentence, is looking about whether the statutory authority for detention overrides the common law provisions. And all it has done is expressed it in colourful language. And there is a risk if the new or if a new factual assessment exercise has gone into now, that traps will be fallen into. But we do accept that the courts below have accepted many of the criticisms that are made. They have made findings, and some of the events have been described in unflattering terms, both by Mr. Justice Davis and by the Court of Appeal. And we accept those, and we're not seeking to invite this court to depart from that. What we respectfully say is that that is the basis on which the facts of the case should be approached. To show the court that even before Mr. Justice Davis, all of the key documents were already available, can I ask the court please to go to his judgment, which is in Core Volume 2. The judgment itself starts back at page 59, but if you can go straight to paragraph 43, which is on page 73.
Page number again?
Sorry.
Page number?
It's page 73, please.
Yeah.
You see that at page 73, in paragraph 43, which actually goes on with a number of subparagraphs over a number of pages, that some of the source documents were directly referred to by Mr. Justice Davis. They included documents which tended to suggest that a blanket policy was in operation. This was one of the factual issues which was finally resolved by the Court of Appeal. So if you look at 43.3, at the moment CCD are pretty much detaining all FMPs without proper consideration or review process. 43.4 seems to be detention is assumed for task force cases, etc. 43.5, the first sentence, including the phrase, we have been detaining all task force and flow criminal cases. 43.8, the quote, which is actually at the top of the next page, in recent months we have been detaining all criminal cases, and the underlining is noted to be original. And 43.9, 43.12, not going to read those out, but clearly these are key documents that were before Mr. Justice Davis. I think some of them were referred to by my learned friend Mr. Westgate. This has not changed. This has all been before the courts right from that hearing before Mr. Justice Davis. There were documents which tended to suggest that the Secretary of State knew that the policy was potentially unlawful. So if I can give you the paragraph numbers, it's 43.1, 43.2, 43.6, 43.7, 43.12. That last one is the document which contains a comment that Mr. Justice Davis described as cynical and unedifying, and the underlying practice as deplorable. It can't, we respectfully say, be suggested that we've been hiding any of this from the courts. As my friend Mr. Beloff has already pointed out, much of the evidence contained legal advice, that is to say, privileged material, the privilege for which was waived. An example of that is at 43.2. LAB, that's Legal Advisors Branch, advised us earlier today that the practice of detaining people in this way was unlawful and that we are particularly vulnerable to challenge. Mr. Justice Davis also had documents tending to suggest that one of the reasons for relaxing the policy was because of pressure on prison detention centre space. So that's 43.7. There are documents which tended to suggest that the courts had been misled in the past. 43.13 on page 76 and 43.19. And then there were documents which tended to suggest that the only reason that the unpublished policy had eventually been published was because it had been revealed in the Ashori and Lumba litigation. So that's it's referred to at paragraph 44, but not quoted. And of course, many of these documents are properly described as embarrassing and damaging to individuals, named individuals. The Court of Appeal had more, we accept, but we respectfully say that it's fair to describe it as more of the same. And you can see that if you look at the document at page 405 and go through it and look at the bold paragraphs. There is more, but it isn't substantially different. The picture was already there before the courts. We should say that the disclosure of the policy was voluntary because before the hearing by Mr. Justice Collins of WL's case on the 4th of July, before his decision on the 4th of July, the first witness statement of David Wood had been prepared. And then, of course, before Mr. Justice Davis's hearing, the second witness statement, long witness statement, had been prepared, which set out in some detail what had happened and disclosed many of the documents in copy. So that is material which was all put before the courts by us without orders having to be made. Before the Court of Appeal, we further voluntarily disclosed, and in good time, David Wood's review, which was properly described as new evidence because it had taken place after Mr. Justice Davis's judgment, but before the Court of Appeal hearing. And that was voluntarily disclosed to the appellants, and the Court of Appeal relied on that very heavily when they came to their adverse findings. That's when they went further than Mr. Justice Davis in relation to what the policy had been. Again, it cannot possibly be said that we had been hiding any of that. So we respectfully say that when we have described the further disclosure in tranches as more of the same, that is an accurate description. There has been, when one looks at the whole picture, one cannot say that we have breached the duty of candour in any way. Because we have put the picture before the court, warts and all, and as learned friends would probably say, there were plenty of warts. And we say that it's significant that when learned friend Mr. Westgate made oral submissions about this on Tuesday, that he referred to only 2 documents which have been in the latest tranche of disclosure. That shows how little the new disclosure before this court adds to the case. In terms of the principles relating to disclosure and the evidence, we respectfully say that it's important to bear in mind the following matters. First of all, the disclosure exercise is not one of standard disclosure that one sees in ordinary civil litigation. Expressly, that is not applicable to judicial review cases. The duty is summarised in the 48-page document at paragraph 130. I don't need to ask you to turn that up because we don't take any quibble with that. But what it does mean is that we don't have to disclose every single document that is relevant. That is a key difference between standard disclosure and the disclosure exercise and the candour that we have to discharge in a judicial review case.
What was that reference to? Paragraph 130 of what?
130 of the 48-page document submissions, that the updated Annex B.
Yeah, thank you.
It's on page 46, so it's near the end of that document.
Right.
The appellant's approach has actually got much in common with an exercise of standard disclosure, going through and asking for every single document which might be relevant. But we respectfully say that the discharge of the duty of candour can be achieved, and has been achieved in this case, without without standard disclosure having to be mimicked. All the disclosure that we have given in this case has been voluntary. We've, of course, responded to requests, and we've made further specific searches in response to requests that have been made. But no orders have had to be made. Nevertheless, we have voluntarily disclosed much damaging and embarrassing information on the issues. As I've already demonstrated, all of the key documents and information was available to Mr. Justice Davis, except for the review which didn't exist at the time, which we then voluntarily disclosed after that. No orders for cross-examination have been made. And this is an important point, as my learned friend Mr. Beloff has adverted to, in relation to the suggestion that this court should now make adverse findings against named individuals, such as Ms. Honeyman, such as Mr. Wood, against whom allegations have been made below, but the courts have not found it necessary to go or to make adverse findings against them. We respectfully say that it would be quite unfair for this court now to go further than the courts below and to reject their explanations for what has happened without giving them an opportunity to explain themselves. What we do accept, as I've said, is that the timing of some of the disclosure was unsatisfactory, and in particular the disclosure that was given the working day before the Court of Appeal hearing. But in the event, we respectfully say that's not something that has hampered anybody, because the Court of Appeal had the material in a digestible form, and we have apologised, and we do so again, for the inconvenience that has caused. There has been criticism of the search methods, which we respectfully say is misplaced. For this, can I ask you to take the authorities volume 37 and to look at the document which may not be familiar to you. It's at tab 377. And it's a document containing guidance on discharging the duty of candour and disclosure in judicial review proceedings. It's produced by the Treasury Solicitors Department. There was a review and recommendations made, and this is the product of it. The appellants have fairly noted in their submissions at the beginning of Appendix 5, their submissions about disclosure, that this postdates the substantive work of disclosure, of searching for documents and disclosing them in this case, because it's January 2010. But nevertheless, they suggest that the method of searching was in gross breach of the principles set out in here. We respectfully say that that's a misreading and a partial reading of what's contained in this document. On page 179 of this print, I think it comes
Which
from...
tab again?
It's 377, please.
Page.
And page 179, I think it's been copied from the Journal of Judicial Review. You see that there are summaries of the duty of candour and the golden rules for conducting a disclosure exercise. Going over to 180, the obligations are then explained in some greater detail. The values set out, including reference to the civil service obligations, the duty of candour described, and solicitor's duty. set out at section 1.3. And then when it continues over to 182, there are a number of lettered bullet points relating to the principles of disclosure in ordinary litigation, that's in standard disclosure. And it is those lettered points that have been quoted by the appellants in their submissions. And it's alleged that the search process in this case has been in gross breach of them. But can I ask you to go nearer the top of the page in the fourth line, where it says that after having noted that standard disclosure is not usually required, it says it will be necessary for the solicitor with conduct of the case to have undertaken an exercise equivalent to the exercise described in the next bullet point. And further on in that note, more guidance is given as to how that is to be done. On page 184, at the bottom of the page, there's sections about roles and responsibilities. It is useful to think of disclosure as a project which requires a project manager of appropriate seniority and experience as a single directing mind. This is particularly important with multi-agency, multi-departmental litigation, and so on. And then at 2.1, it sets out the points for the role of the TSOL, the Treasury Solicitor Case Handler, who is to have overall responsibility for the disclosure exercise, agree with the defendant departments and non-party departments what the process should be, etc., etc. And then if you go over to the next page at 2.2, it's the role of the defendant department to nominate a single contact point, usually a departmental lawyer, to liaise with the case handler and ensure that the department's views are represented in discussions concerning the litigation it's handling, suspend document destruction policies where necessary, provide the case handler with details of how the department records, handles and stores information that might be of relevance to the issues in the case. Then can I draw particular attention to this? Appoint a person of suitable seniority and experience of the organisation who may or may not be a lawyer, but who understands the obligation of disclosure and duty of candour to supervise identifying potentially relevant documents, information and their location, identifying non-party departments who may also hold documents, collating bundles of documents for review, identifying relevant individuals who are likely to recollect relevant documents information, explaining searches made and not made for reasons of proportionality, claims of PII or privilege, keeping the case handler informed, liaison with those who handle freedom of information, DPA requests in the department as appropriate. And then on page 189, there's a section dealing with the search and how the search is to be conducted. But the headline allegation that's made by the appellants in relation to the search and disclosure is that an official in the Home Office was entrusted with this primary evidence collection exercise. And we respectfully say that even if this guidance had been in force at the time that the exercise was conducted, that would have been perfectly in accordance with the spirit of the guidance. No doubt that the detail would have been sorted out in accordance with the actual detail of the guidance. But there is no gross breach of these principles at all. And so the submission that the appellants make on this, we respectfully say, is misplaced. And so, in conclusion, we respectfully say this, that the material that was before Mr. Justice Davis and the Court of Appeal were sufficient, amply sufficient, to satisfy the duty of candour, to give a full picture of what was going on, even if not every relevant document in the standard disclosure sense was produced to them. Both Mr. Justice Davis and the Court of Appeal were perfectly entitled to find that there was no breach of the duty of candour, that particular allegation having been distinctly made before both of them, and the evidence examined by those courts. The Home Office has been open with the courts, and the result is that we respectfully say that this court should not go beyond what the courts below have found, having reviewed the evidence and made their findings. And in particular, this court, we respectfully say, should not go further in relation to the individuals who have been personally criticised, because they have not been afforded any opportunity to answer those allegations. It isn't an attractive picture, we accept, on the substance of the case. That is why we are here. But in terms of the production of evidence, the disclosure to the courts and explaining to the courts what has gone on, we respectfully say that our duties have been fully and properly discharged and there is no proper ground of complaint. And we respectfully ask the court so to find. I think that just in conclusion, I should just refer to what would, if the court is against me on that, what would be the effect on the case. And that is what we have put in 1126 of our printed case. Then from Mr. Beloff dealt with that. It goes to costs and not to damages, but I don't think I need to say any more than that. So unless I can assist any further, those are the submissions.
Thank you, Mr. Tan.
My lords, my lady, I'm going to begin first by replying to the Hardial Singh issues, and I want to distinguish and make clear between the idea of voluntary repatriation and the idea of non-cooperation with the process of removal. We repeat our submission that voluntary repatriation is irrelevant to the purpose for which detention is effective, because the detention is for the purpose of removal or deportation rather than a departure. And that is clear from Hardial Singh and the common law cases which look at it. And you get that from Hardial Singh itself, 762, page 706 D to E. Mr. Justice Wolfe, as he then was, and Lord Bingham in Belmarsh at 14, volume 14, tab 138, paragraph 8. Under Article 5, where the position may not be so clear, I accept, my Lord, the President's point that at first sight it looks as though you can detain people while deportations are in process. In fact, the position has moved on since Chahal, and the authority which Mr. Fordham referred to, Sadi, which says you have to have a close connection between the detention and its purpose, has been applied to the deportation limb of the article, as well as the entry detention limb of the article. And the authority is the Belmarsh case in the Grand Chamber. It's called A and Others, volume 26, tab 252, at paragraph 164. It applies Sadi, mutatis mutandis, to the second limb. Hence, it is not appropriate, it's a detention, it isn't permissible while deportation proceedings are in place. Detention has to be because of those proceedings. You need the close connection. We accept that a failure to cooperate with travel documentation and so forth is of itself relevant, because that is apt to frustrate the machinery of deportation. You've had my submissions on the qualification. I want to take you, my lords, very conscious of the time, to the Kadzoev case very briefly, because it contains the return directive, and we've always accepted that no direct issue of EU law arises because of the opt-out. But equally, it is simply wrong to say that the EU instrument cannot inform the article because of our opt-out. The Strasbourg Court has well established that an instrument may be used as an interpretive tool in discerning the meaning of the Convention article, even though the respondent state in question hasn't ratified it. And the leading case now is a case called Demir and Beykara. It's a collective bargaining case against Turkey, and we deal with it in our case, in the single WL case, at paragraph 63 to 65, 102 to 107. The reference is 27259, volume 27, tab 259. The critical paragraphs are 76 to 86. Now, what it said is, against us, is that collides against clear Grand Chamber case law, which lays down essentially the Hardy-Alsing limits. Well, we're not for a moment saying that the effect of the return directive is to impose a time limit for the purposes of Article 5.1f, but it is still informative, we say, of the question of reasonableness, an open-textured question, but something that now takes as an inspiration for its meaning the maximum time limit of 18 months which the return directive imposes, and it imposes that where you have a failure to cooperate, the maximum time limit goes up from 6 months to 18 months. Can I take you very briefly, my lords, my lady, please, to the Kadzerv case? It's volume 28, tab 273. And at paragraph 6 of the Advocate General's opinion, he sets out, Advocate General Mazak, he sets out page 480 of the weekly law report. So I could make a very weak forensic point and say that the law reporters obviously think it's of some importance. And you'll see it's going to be going into the law reports themselves. It's volume 3 of the weeklies. At bottom of 480H, Article 15 is set out, unless other sufficient, and the first thing we note is you've got a very, very tight necessity test for detention. But that's very much by way of background. I'm not saying for a moment that entitles you to disregard the Sardi's jurisprudence. Unless other sufficient, less coercive measures can be applied effectively in a specific case, member states may only keep in detention a third country national who is subject to return procedures in order to prepare the return or carry out the removal process, in particular where there's risk of absconding. Third country national avoids or hampers the preparation or return. Any detention for as short as possible, etc. The review requirement, which my lords, my lady may recall from the SK case, and then subparagraph 4, where it appears that a reasonable prospect of removal no longer exists for legal or other considerations, or para 1 conditions don't exist, detention ceases to be justified, the person concerned shall be released immediately, and then the limiting period of 6 months in subparagraph 5, and in subparagraph 6, the limiting period it can be exceeded maximum of 12 months, where A, lack of cooperation, or B, delays in obtaining necessary documentation. Transposition date next month, 24th of December. Can I take you next to paragraph 74, which of the Advocate General's opinion, which deals with the question of whether challenges can extend this period. It's the appeal of Mr. Tan and Mr. Beloff's exclusionary rule. As far as the Advocate General is concerned, and we'll see that as far as the court is concerned as well, a flat rejection of that. 74, page 493D. Clear that the suspension of the removal decision because of judicial review proceedings brought against the decision doesn't appear amongst the grounds for extension. In any event, no provision is made for any extension beyond the additional 12 months. Then consequently, it can't be extended beyond the maximum duration. And then at 89 over the page, this deals with the question, Mr. Tan's idea, which you switch in and out of return directive detention by reference to whether or not you can be regarded as an asylum claimant. That's completely wrong, with great respect to him. The critical distinction is the basis upon which you're being detained. Is it for the purpose of removal, or is it for the purpose of processing your asylum claim? And you can make your asylum claim and be detained for the purposes of removal. It's a question for the national court. And in those circumstances, you continue to be detained for the purposes of this directive, as Mr. Tam appeared not to contest. I say not to contest rather than accept, because of paragraph 1512 of his printed case. So
none of this is relevant because UK has opted out and it's not suggested it's reflective of public international law.
No, my lord, public international, if you had a customary rule, obviously it would apply.
But it's not suggested this.
No, but we have been very careful to say the relevance of this is through the medium of Article 5. That's where it's relevant. And it provides an example of where the comparative European approach is going. Ireland and UK are the only two states that have opted out. Ireland has maximum time limits anyway, I think, of 2 months. And the relevant paragraphs of the court's judgment, which begins at page 498, are 47, the point about applying, potentially applying even when an asylum claim is made. And the key sentence is, the opening one, should it prove to be the case that no decision was taken on Kadzo's placement in the detention centre in the context of procedures open following his application for asylum, so that his detention remained based on the previous national rules, and they say that's the issue. So what is the purpose for which the removal is made? 49 to 54 periods on appeal subject to challenge counted. Paragraph 60, 63, 65 to 67, the idea of realistic prospect of removal. We say it's not enough to have some prospect or sufficient prospect, as suggested by the Court of Appeal in Ace Somalia. You've got to have an evidence-based, realistic prospect with an indication of likely timescale. And then the maximum period, 68 to 70. That's all I need to take you to Kadzo for. Mr. Tam, in his note, also refers to Article 2.2 of the directive, which makes its application optional for certain classes of persons. That's an article which he didn't refer to in his printed case. We referred to it in our printed case, pursuant to our duty to the court. We deal with it at paragraph 65. We deal with it at paragraph 65 of the of WL's case at footnote 35, and the document referred to at footnote 35 is at volume 33, 339, and it's the passage at the end of that document. My lords, I'll just remind you, because you've got the chronology set out at paragraph 13 of Mr. Tam's note, I indicated to you that the most recent appellate proceedings were conceded not to be certifiable by the Secretary of State's officers, and the reference to that, I'll just give it to you again if you want it, is Appendix 3B, 2665. So the appeal issue is to be seen against the context where the Secretary of State herself or her officers did not consider the appeal was certifiable. It didn't. Wasn't prima facie lacking in merit. It wasn't clearly unfounded. As regards the question of the current legality of detention, we lay stress on the time that has passed, the fact that appeal rights haven't exhausted, and we say there is a clear clear basis for rejecting the exclusionary rule. You've got no statutory warrant for it. So why on earth would someone impose such a rule? And you've had my submissions on this man's very poor ill health, his schizophrenia, and the fact that he has a care plan and risk management plan in place. It's all in the statement of facts and issues. There's nothing materially different between the position now and the position before the Court of Appeal, save for the effluxion of time. The only new evidential issue of relevance is the latest medical assessment from a very eminent consultant, Dr. Katona, and you have that at Appendix 1A, 2334. So this is not a task of intensive factual scrutiny which the court would have to carry out if it were minded to accede to our application to consider the current legality of his detention. My Lords, very quickly, the question of public protection, we see the force of my Lord Rogers' observation to Mr. Fordham. Can't a state say, well, the individual, if released, will commit an offence, be convicted, and that would frustrate the deportation process? The reason, with respect, we say that point has force is because it brings the issue back to the purpose of the detention. But we do say that even in that circumstance, the counter-argument is that the individual is entitled to the protections that he would have in a criminal trial, and it's not appropriate simply to prolong his detention if that is the only reason why he is being detained. Can I hand up that's all I want to say about the Hardiel Singh aspect of the case. Can I hand up two documents, please? And these were prepared because we thought there may be an issue of time. The first is a note in reply which deals with the points that Mr. Beloff made as of yesterday. And the second document is a note that Mr. Rabinder Singh prepared, and which I would like to adopt. I'm very grateful to him on the presumption issue. Do you have some more? Hurry up. Okay. Very sorry for the delay. It's regrettable. Do my Lords have a copy of the documents? My Lords, my Lady, first of all, we set out a list of concessions which Mr. Beloff has made. 1.1, that it was, the policy was adopted. In addition, today, he appeared to concede, if I'm wrong, the issue of burden of proof. It lies upon the Secretary of State if the causation analysis is accepted both for liability and in terms of damages. That was not the position in Mullen & Friends' printed case. He also conceded that the errors in this case were at the serious end of the spectrum, something which manifestly is the case. Publication was dealt with at 1.2, the concession with regard to that. We've set out a caveat on the issue which my Lord Sir John Dyson raised at 1.4 on the issue of process and substance, disclosure of policies going to process and substance. At paragraph 1.5, we deal with a concession which Mr. Beloff withdrew this morning in answer to Lord Hope. Was there a requirement to formulate policy? But it doesn't matter to our analysis. See the penultimate and final sentence of paragraph 1.5. And we deal with Mr. Beloff's treatment, if I may put it in that way, of the issue of the policy before November 2007, and my Lord Brown has already referred to the paradox that it was blanket after, not blanket before, even though it was supposed to relax the policy. I'm not going to say anything about paragraphs 2 to 5 of the note. Paragraph 6 offers you, my lords, my lady, another juridical basis for the duty to follow policy absent good reason. We say it's time for it to stand on its 2 feet, and we refer to Professor Craig. On the issue of presumption, our submissions are set out at paragraphs 9.2. We say that Mr. Beloff's conception of the right to liberty at common law is impermissibly austere. He reduces it to a legal rule. How, in heaven's name, does that explain how executive powers of detention, Mr. Beloff says it's a legal rule in judicial proceedings. How does that explain how executive powers of detention are to be narrowly construed? How does it explain that the fact that the tort of false imprisonment is actionable per se? How does it explain, we say, my Lord Hope's observation in Belmarsh, that it is impossible ever to overstate the importance of the right to liberty in a democracy? You don't do that by reducing it to a legal rule. And how Lord Bingham, in the same case, when he was dealing with the issue of whether or not overbroad powers of detention, the statute permitted detention without trial of international terrorists, the derogation was limited to Al-Qaeda. And Lord Bingham said it was an occasion in which the appellants were insufficiently robust. It hadn't been argued for once by the appellants that was objectionable because they relied on an undertaking given by the Attorney General. And Lord Bingham said, it is not, however, acceptable that interpretation and application of a statutory provision bearing on the liberty of the subject should be governed by implication, concession, and undertaking. He said that at paragraph 33. It doesn't explain why it is only, Mr. Beloff's submission doesn't explain why it is only a court under the 2005 Act that can impose a control order which deprives someone of their liberty. We say, with respect at paragraph 12, that Mr. Beloff's submissions on the principle of legality are sophistic, and you've got the submission there. General words, may, release, etc., are to be interpreted subject to fundamental rights at common law. You need an express ouster or an express authorization of those rights, or an authorization which arises by way of necessary implication, that is, by logic, not on the basis of expediency. As far as Sadi is concerned, we say Sadi did not, at common law, in the House of Lords, it did not contain a policy of presumptive detention. We say the general presumption in favour of release still apply, and you see that. I'm just going to give you paragraph references. You see that in the current version of the policy. That's at volume 2, tab 21, paragraphs 55.1, where the general presumption is stated. There's then an approach, 55.1.3, from which Oakington cases are excluded, but they're excluded because of the absconsion issue. My Lords, that's all I want to say about our note. Mr. Rabinder Singh's note, the only thing I would say is in relation to the H case, which Mr. Beloff handed in. I would refer you in particular to paragraphs 24, 29 and 31 of the judgment, and also the form, that's 24, 29 and 31 of the judgment. I will also refer you, my lords, my lady, to the final clause of the declaration that was made, which makes it clear that the court was concerned not just with burdens of proof, but the substantive legal rule. It found that offensive, as well as the fact that the burden was wrongly placed. May I now please move on to the issue of causation? My lords, we had, if I may say so, beautifully presented heresy from Mr. Beloff, which it was a pleasure and a privilege to hear, but heresy nonetheless. The simplicity of his 12 points begins to collapse when he accepts that he must read in, at paragraph 8 of his points, the hard-yield-sing principles, which, on the highest authority, by Lord Brown in Kadian, go to the exercise, not to the existence of the power. He appears to accept that Cooper and Wandsworth would be accommodated by point 8. And that is, of course, a classic case. Mr. Beloff said that we were not here in the terrain of classic cases of false imprisonment because we were not condition precedent cases. But as my learned friend, Mr. Rabinder Singh, submitted to you, and as my lords, my lady may recall, in the SK case, I also referred to the case. This was a trespass case, and not about no authority. So if that goes in, as Mr. Beloff appeared to concede, I hope I haven't got him wrong, if that goes in to paragraph 8, and you have Padfield in paragraph 10, well, why does one leave out what remains of public law? The duty to follow policy, absent good reason. So we say that this is an unstable list. The dishes on the menu run into each other and create something which the court should find inedible, with great respect. Mr. Beloff also placed reliance on the sword-shield distinction. The Winder case, approved recently by this court in Pinnock, well, that doesn't begin to run here. We are dealing with false imprisonment. We are dealing with an invasion of rights to which the individual responds by bringing a claim. In Winder, the individual could sit back on his rights and wait for the rent arrears proceedings to be brought, the possession proceedings to be brought, and then bring his public law claim by way of defence. What is a person in this position supposed to do? Davey and Spelthorne, at volume 7, tab 61, is another example where the shield-sword distinction was disregarded. That was a negligence claim, which had as an essential ingredient the demonstration of a public wrong. We are a fortiori here. We're not negligence. We're false imprisonment actionable per se. And there the House of Lords disregarded the sword-shield distinction. You have the acting in the... then you have the criminal cases where the issue is whether or not the police officer was acting in the execution of his or her duty, where if an individual tries to escape or resists arrest, the issue of trespass arises in a defensive context. Then you have ultra-virus contracts, the Credit Suisse case, Lord Justice Neal. Again, these are cases which demonstrate, we respectfully submit, that this distinction cannot begin to bear the weight that my learned friend puts on it. You have incongruence between private law remedies and public law remedies on Mr. Beloff's construction. He seems to accept that, generally speaking, at least I hope, generally that the full range of public law grounds are available when one is challenging a deprivation of liberty, but he restricts that which is available when one is claiming in the tort. And that raises the congruence issue, which my Lady Hale raised with Mr. Tam in the SK case, if I may say so, and something upon which my Lord Kerr repeatedly questioned Mr. Tam on in the SK case. My lords, my lady, the Sardi case, you have our submissions at paragraph 114. We weren't ducking or parking the issue about the tension between Christian Leszczynski and Sardi. We deal with it in a footnote at 46. Footnote 46 is quite a dense footnote, if I may put it that way. Essentially, we say you don't have to decide it, but if you needed to decide it, we say that Sardi, where the point simply wasn't argued, isn't consistent with it. The reason you don't have to decide it is because this isn't a reasons case. And also, what is most pertinent is Mr. Beloff made it clear that there are two senses of cause which need to be kept distinct. There's the influence or subjective nature. Was the policy operative in the mind of the decision maker? And then there's a reconstruction issue. What difference would the decision would it have made? Mr. Beloff says that Sardi supports him on causation because the flawed reasons in that case didn't sufficiently closely relate, he says, to the actual decision. But that was only in the sense of influencing it. That's the point we make in our case at 114 subparagraph 1. The real reason in the Sardi case was a lawful one. And the document was simply erroneous and therefore irrelevant to the real reason. Here it is common ground. We're very grateful for Mr. Beloff after the, if I may say so with respect, the equivocation in the printed case on the issue. Hypothetically could or could not have been taken. Not particularly helpful when the case reaches this level. It's common ground that the decision influenced, that the policy influenced the decision to detain. And therefore, we say that the Sardi case and what we've got here can clearly be distinguished. And you've heard my submissions on causation. It's not right to say when the case, but point of detail, the Strasbourg court found a violation of 5.2. I've always accepted at 5.5 you apply causation test. Now, finally, on the facts, you have our submissions in our case on the counterfactual, paragraph 138 to 141. If I lose on the causation defence, on that issue, what would have happened? Now, we say that the Secretary of State should be regarded as having lost the benefit of a benign counterfactual. We don't know what would have happened had the decisions not been taken by reference to this policy. It is wrong, we respectfully submit, to posit legality. What is to say that some other unlawful policy would not have been formulated? And the point, but by reference to the refusals of bail and so forth, before Mr. Justice Collins, before bail judges, obviously has great forensic force, but it is reduced, we respectfully submit, by the fact that judges take seriously Home Office assessments and Home Office views and pay deference to those views. And if those views are tainted by illegality, it is not safe, we respectfully submit, to reason that the individual would have been detained in any event. In KM's case, there are three facts I would point to. He complied, and they're set out at SFI, Statement of Facts and Issues 48, 49, 55, and 57, and 67. Firstly, he complied with licence conditions on release from his criminal sentence on the 31st of March 2006. He complied after service of the notice of intention to deport, and he was detained from his home 9 days later on the 19th of May 2006. He cooperated with travel documentation by completing the forms. You have that at SFI 55. He attended the High Commission of Jamaica 57, and there still is no travel document. He was released on bail in July 2008 and has complied since. Equally, we say that if you look at the factors which are set out in the lawful policy, we say that WL also, it is not inevitable in his case that he would have been detained. He had claimed asylum on arrival in the UK and complied with immigration law. It is completely wrong, as some of the detention views suggest, to say that he arrived unlawfully. He entered unlawfully. He arrived unlawfully. It's the Ademi Asfor, Article 31 situation of arriving on false documentation but not crossing control. So you don't effect an illegal entry. He claimed asylum on arrival. He had no history of absconding whatsoever. He had a wife and British son. He had an outstanding appeal. He was known, or ought to have been known, to be suffering from serious mental illness. The first report dates back to October 1999, where he is diagnosed as being a paranoid schizophrenic. My lords, my lady, unless... Sorry. Those are my submissions, unless I can help you further.
Thank you very much. The Court is grateful to counsel for their submissions and will reserve its judgment.